I'll call the second case now in the matter of the denial of a contested case hearing. Okay, so we got a lot of lawyers here. We're going to give the first counsel on each side the 3 minutes. Ms. Maccabee and Mr. Bryson, you'll get the 3 minutes of uninterrupted time, and at the 3-minute mark, I'll interrupt you. The rest of you are subject to our questions immediately. And as I understand it, you're also dividing the rebuttal, and we've got 3 of you arguing, so we'll do the best we can. And with all of that, Ms. Maccabee, you may proceed when you're ready.
May it please the court. I'm Paula Maccabee representing WaterLegacy. Appellants all request that the NorthMet permit be reversed. Here's the roadmap for our arguments. First, I'll argue that MPCA's improper procedures and failure to set water quality-based effluent limits, which I'll call Q-bells to avoid the tongue twister, require reversal of the NorthMet permit. Second, Matthew Murdoch will argue for the Fond du Lac Band of Lake Superior, Chippewa, that the NorthMet permit violates federal law and harms the band. Third, Evan Nelson will argue for conservation organizations that the permit violates state groundwater rules and that MPCA's conduct may have prejudiced substantial rights. I now speak for WaterLegacy. The NorthMet permit fails MAPA's standards for regulatory integrity. The Court of Appeals and the District Court both agreed, quote, MPCA did not want EPA to submit a comment letter during the public comment period. The MPCA knew that it was required to respond to all written comments. Its responses would be public, and the public would find out what the EPA's specific concerns about the permit were. Another quote, MPCA's primary motivation was its belief that there would be less negative press if EPA's comments were delayed. The courts also found MPCA unlawfully failed to preserve official records that would have exposed MPCA's conduct. The court should not adopt a rule of law that lets MPCA get away with this. Appellants' rights under MAPA 14.001 to public access, public accountability, and a fair record on judicial review were prejudiced. We may never know why the past administration's EPA did not object to the final NorthMet permit. But due to whistleblowers and FOIA lawsuits, we know what was in EPA's comments. We know that EPA's permit program had serious concerns that the permit lacked federally enforceable Q-bells to protect Minnesota waters, and those concerns were never resolved. If EPA's comments had seen the light of day, MPCA may have required Q-bells. MPCA's unlawful, arbitrary, and capricious actions to keep EPA's comments and its own conduct secret may have prejudiced appellants' rights to protect clean water. Reversal is a just and effective remedy. The heart of EPA's comments was the need for Q-bells to protect Minnesota water quality. Great Lakes rules required mercury Q-bells. Clean Water Act rules require mercury and sulfate Q-bells for discharge to impaired waters. MPCA's permits in other cases, like Annandale and Alexandria Lake, relied on Q-bells. EPA's comments demanded Q-bells. The final EIS for the North Met permit said it would contain Q-bells, yet the North Met permit lacked Q-bells for any pollutant.
Counsel, I'm just going to stop you there and see if members of Justice Anderson.
Pardon?
Counsel, the EPA could have rejected this permit and did not. Does that matter here?
Your Honor, it matters in the sense that that's the posture we're in today, but it doesn't matter in terms of the EPA's interpretation of the Clean Water Act and the Great Lakes Initiative, because as a result of the Freedom of Information Act, we have the document, and EPA says that the permit would violate the Great Lakes Initiative, violate the Clean Water Act, and EPA is a co-regulator. So its opinions are entitled to deference, not only under the U.S. Supreme Court's case of Arkansas against Oklahoma, but in the Annandale case, this court said not only that the MPCA was entitled to deference for its long-standing and reasonable interpretations, but so was EPA. So in this case, what we have in front of us is the EPA's interpretation of the law, it's federal law that it enforces, saying this permit's no good, and then we have silence.
But the point that I'm making is, if you're right about the inappropriate conduct by the PCA, the EPA had we know now, thanks to whistleblowers and FOIA requests and so forth, that they had the necessary information but chose not to act. And I'm just wondering if, this isn't a mistake that, or something that PolyMet did. This is a administrative issue, and I'm just wondering if that matters any, the fact that the EPA ultimately chose not to do anything.
Your Honor, I don't believe it matters in this case because this court is not judging EPA or the past administration. What this court is looking at is, do we have a deficient record? Because there are two regulators, and the MPCA only considered its own views and did not even analyze the Great Lakes Initiative, didn't analyze EPA's comments, and didn't even explain its deviation from its own prior practice. So what we have is an inadequate record as a result of unlawful and arbitrary and capricious procedures. And the other thing, if you read this case, there is no party that says that the Minnesota Pollution Control Agency lacked discretion to impose Q-bells. And we believe that if MPCA had been forced to respond in writing to EPA's comments, as the Clean Water Act requires in a usual case, and if these comments had been revealed to the press before the permit was issued, the petitioners may have prevailed. EPA may have prevailed, and there may have been a stronger permit that is more protective of Minnesota waters and Minnesota health.
I'm going to ask one more question, and then
Yes,
I'll
sir.
get out of the way of my colleagues. And I want to dive into a little bit of the detail here, dealing with the internal operating limits issue, which
Yes, sir.
is raised by a variety of the appellants here. If PolyMet breaches those internal operating limits, can WaterLegacy or someone else sue? And secondarily, if they breach the internal operating limits, can PCA revoke the permit or otherwise take administrative action?
Your Honor, the EPA concluded that the internal operating limits would not be enforceable in federal court.
Concluded in the draft comment, right?
That's correct, and that's actually a fair reading of the Iowa League of Cities case. So MPCA still may be able to enforce, quote unquote, the permit with its compliance schedules, its remedial measures as the permit dictates. But everything in this record suggests that the internal operating limits would not be federally enforceable. They were not implemented in the permit under any part of the Clean Water Act, and they're not even implemented under the part of Minnesota statutes that refers to navigable waters. They were only put in under a very small provision that has to do with disposal systems. And they were very explicitly internal waste stream limits, which is exactly what the Iowa League of Cities case says are not enforceable under the Clean Water Act. And the Clean Water
So
Act is
could-
very...
I guess, could they
Yeah.
revoke, could PCA revoke the permit if they were not meeting the internal operating standards?
It is possible that PCA could take all kinds of action. But as Your Honor knows, as a result of the U.S. Steel Mintac case, if the only remedy is available is that PCA may exercise discretion, it is possible that the pollution would be existing for years, or in the Mintac case, even decades, without an effective remedy. Whereas the Clean Water Act, by allowing EPA to take action and citizens to take action, creates a potential for penalties, injunctions, and
So-
even criminal prosecution. It's a much more...
So it's a more robust, so there's a potential that there could be some impact, but if it's under the Clean Water Act and the Q bells, then it would be more robust, and more people more people would have standing, essentially.
Well, actually, Your Honor, that's exactly why the 1972 amendments of the Clean Water Act were formed, is to make sure that there was an effective remedy based on end-of-pipe limits that would allow enforcement. And you have it exactly right, that the federal enforcement is more reliable, more robust, and isn't dependent on the discretion of the MPCA.
Thank you, Counsel. Your red light's on. Mr. Murdoch, you're next. For 8 minutes.
Before I forget, and to the extent you know, do the internal operating limits have, in the Court of Appeals brief, which as much as I know about it, they list arsenic, copper, lead, and mercury, but they don't list things like cadmium and zinc. Do you know if there's internal operating limits on those materials?
No, Your Honor.
You don't know, or there are not?
I can.
Well, no, I'll ask them. Okay.
There are in our brief, I think those are correct. I think that is correct. There are pollutants that there's no operating limits. There's T-bells, but there's no operating limits.
Right,
So
okay.
there's
Thank
literally, and that's sort of the critical issue that Ms. McAbee was getting at, is that the T-bells authorize the discharge, and that's significantly greater than the applicable water quality standards. There's two specific pollutants that we've mentioned in our brief that there's no operating limits. And I am Matthew Murdoch for the Fond du Lac Band. Good morning, Chief Justice and members of the Minnesota Supreme Court. If I may, I would like to discuss how MPCA's arbitrary and erroneous permitting decision prejudiced the band's substantial rights in protecting the surface waters of the St. Louis River watershed, including waters downstream in the Fond du Lac Reservation. The band's reservation was established in 1854 as its permanent homeland and lies directly downstream of PolyMet's proposed discharges. Upstream discharges from mining have degraded the reach of the St. Louis River within the reservation to the point that today it is unsafe for band members to engage in subsistence fishing due to toxic human health effects from mercury-contaminated fish. The band has worked hard to address these issues for several decades and obtained treatment as state status under the Clean Water Act in 1996 to implement a water quality program to protect and restore the reservation's waters now and for future generations. The band has several federally approved water quality standards that are more protective of water quality than Minnesota's, such as designated uses to protect subsistence fishing and a mercury numeric criterion that is half as low as Minnesota's. These standards are critical to ensure that band members are able to maintain their cultural and religious traditions as well as subsist off a traditional diet of fish. And now PolyMet seeks to discharge millions of gallons of polluted wastewater per day into the headwaters of the St. Louis River.
Counsel, what relief is the band seeking here?
Your Honor, we are seeking reversal of the Court of Appeals decisions on all the issues that we believe it erroneously affirmed and the permit. The relief we would seek is for this court to order that MPCA republic notice a draft permit so the regular oversight process can take place.
So just to make this, maybe I'm oversimplifying, I'm sure I'm oversimplifying it. What you're seeking is return to the status quo ante, that we're going to start all over with a public comment period for everybody and move forward from that point.
Correct, Your Honor. We do.
Go ahead.
That's essentially where the process sort of went awry with EPA's comments. That was the regular oversight process was for EPA to submit its written comments during the public comment period, for MPCA to respond to those, and so just to re-public notice the draft permit.
You mentioned the fish issues, but I don't see anything in the draft comment that deals with those. Am I correct about that? I mean, they don't comment specifically on the Great Lakes Fish Initiative and things of that sort?
The EPA does comment on the ban standards. This is at addendum 193 of the ban's addendum, where it's mentioning the standard for mercury. It's essentially referencing the ban's numeric mercury criterion, which it's lower than Minnesota's because it's calculated to protect subsistence fishing. And so EPA's comment was referencing that standard. And if I may, just to address
can I just to clarify the previous question of Justice Anderson, what if we were just to remand to allow the EPA's comments to come in and have the MPCA have to respond to those comments? I mean, are you saying we reopen it so everybody can comment again, or is it just to bring in the stuff that was missing?
I think it would be to redo the process, just because, EPA is acting under specific authority that it has, and so just to have the comments come back in wouldn't necessarily would do it. I think just a complete redo of putting, and the district court made findings on this, of the regular process starts when the draft permit goes out on public notice. And so that EPA is acting under authority under the MOA, and so that's just the appropriate remedy that we believe this court should order.
The ban be further harmed if we disagreed and just remanded so that EPA would submit their comments and the PCA would have to respond. And if so, I'm assuming the answer to that question is yes. And if so, can you just go a little further into how the ban would be harmed? I'm assuming it's because you were unable to respond to the comments because they weren't in the record, or if you could speak to that, please.
Yes, I think just having, again, EPA is sort of exercising oversight throughout that process. And just to go back to have EPA's comments come in and MPCA respond to them, it's not really clear what EPA would do, because it can object on the basis of the ban standards, and so just to sort of have MPCA basically just go back and respond to EPA's comments, I'm not really sure that would fully allow EPA back into the picture in terms of exercising its oversight authority.
And also, what does the record tell us about how the EPA or PCA considered the impact on the ban as it relates to the cultural and religious practices?
Well, MPCA's record doesn't tell us anything about that. These discussions were going on. Obviously, EPA was having them with MPCA. MPCA did not disclose them. It was in EPA's comments about the ban's water quality standards. Those are not disclosed or discussed. If you look in MPCA's permitting decision, its fact sheet, its findings of fact, there's literally nothing about the ban's water quality standards or the importance of subsistence fishing.
Council, I'm wondering, and this is a question to all appellants, what do we do, though, with the district court's clear findings that, the district court mentions that, yes, there was an attempt, or that the MPCA didn't want this to be a public discussion at a particular point in time. But at the end of the day, the district court makes several findings to the effect that there was no sort of concerted effort to prevent the EPA from commenting, and that, in fact, the EPA could have commented had it wanted to, because the MPCA has no control over the EPA. What do we do with that series of factual findings that the district court made? The first 20 pages or so of PolyMet's brief is just walking us through all of those district court findings, where the district court said, in the final analysis, there was no concerted effort here. What do we do with that? And maybe this is just going to what our standard of review here is.
Well, Your Honor, I think a lot of those findings are based off of an erroneous interpretation of the law of what an irregularity in procedure was. And so the district court concluded that it can only be an irregularity in procedure if it's a procedure that's adopted in writing. And so all those findings that PolyMet walks you through, they're all based on the fundamental erroneous interpretation. I see I'm out of time.
And that, may I, Chief, just real
Yes.
quickly? And I'm assuming that, do we need to make that finding, that interpretation of whether it was an irregularity, seems to me is a question of law for us to decide.
Correct. And the plain meaning of procedure is simply just the way of proceeding. There's nothing in that plain meaning that requires a procedure, an agency procedure to be in writing. And we cite plenty of administrative law cases where it's unwritten practice, something like that. And so if you apply that appropriate interpretation, then, I mean, the district court's ultimate conclusion that there was nothing irregular here is based off an erroneous interpretation of what an irregularity in procedure is.
Thank you, counsel. Your red light's on. Mr. Nelson, you have 8 minutes.
Mr. Nelson, if you could start with specifically the relief, same question that your co-counsels have addressed, the specific relief that your client seeks here.
Yes, thank you, Your Honor. We seek reversal of this permit back to the agency to republic notice the permit. As Mr. Murdoch indicated, that is where the procedure went awry, and that is where the procedure can be remedied such that the EPA's comments can come in. And more importantly, we can understand what MPCA's response to those comments would be, because sitting here right now, we do not know how the agency would have responded. And that is why, excuse me, the statute calls out for relief when our rights may have been prejudiced as opposed to actually were. The fact that we're talking about potential prejudice is important here because we don't know, none of us here know, what would have happened had the procedure been done correctly. And the only way to remedy that is to republic notice this, to have the EPA comments come in due course, have the MPCA respond to those so those responses can be scrutinized by the public and this court.
Well, that maybe is an argument for, without deciding it one way or the other, that's maybe an argument for remand, but it isn't necessarily an argument for republic notice and providing, again, the public had plenty of opportunity and took it to comment on this. It seems to me, at most, the argument you're making for is a limited remand. Why am I wrong about that?
Because had the EPA comments come in, now granted, in this case, in the facts, they would have come in towards the end of the comment period, but there still would have been time afterwards for the public to make some sort of response to those.
Well, you don't know that. I mean, this is not a court proceeding where appellant responds, appellant files, respondent, then appellant reply brief. I mean, the EPA could have commented at the very end of the process or at some other process. There's no statutory right for response to EPA comments, or am I missing something here?
Well, I think, Your Honor, you hit it on the head when you said we don't know, right? That's the issue, is we don't know what would have happened because of the irregularities, because of the unlawfulness, and because of the arbitrary and capricious decision-making process. And so if EPA comments, then a host of other things may have happened. We may have had supplemental comments that reference the EPA comments. We may have had situations where EPA alerts us to something or others to something that we need to pay attention to. We may have been able to point the Court of Appeals towards what the EPA was saying. All of these things may have happened but did not because of
Counsel,
the process.
is there a timing problem here? I mean, what was the time period under which EPA should have commented here? Are we talking about 2000, 2001, 2019? What's the time period?
The public comment period?
Yes.
Was, and I apologize, I'm probably going to state the date wrong, but I believe it was in 2018. I'm sure I'll be corrected with
Okay,
a
so
sticky note
now
later.
in 2022, there's a different administration in the White House. Is there a timing problem with, when is the EPA going to comment? Are they going to comment effective as of today, or are they going to comment effective as of 2019?
I think, Your Honor, the EPA speaks when it speaks, and they're going to comment now. If this is reversed in republic notice, it's going to be a comment that comes forward right now. And whatever EPA actions follow that would be made when they are made. And so this is not a situation where we are attempting to recreate a record because we're putting something in as it would have occurred at the time. We are reopening a process so it can be done correctly. And that would involve allowing EPA to comment. We know they want to. We know that's on the way. But we need to reopen the period so that can
We
be
know
done.
that from the draft documents that you want us to take judicial notice of, or why are you saying we know they wanted to comment?
Well, I believe there's a motion currently pending whether this court can take judicial notice of the Inspector General's report. We also know that from the district court proceeding where Mr. Perard and EPA testified that these are on the way. And more fundamentally, we know that because MPCA took steps so that they wouldn't come forward. And so PCA knew the comments were on the way, and they would have come in but for PCA's actions.
Would your,
Counsel,
would your
I-
position on the substantive issue here, related to the groundwater rules, would that ever allow for the type of permanent stockpile or flotation tailings basin, which I think are not just, I mean, that particular thing doesn't just exist on this mine. It probably exists on other mines today. Does that prohibit those kind of things?
So,
I
yes,
mean, it seems like that's the gist of your argument, and maybe unless there's a variance, but.
well, actually, Your Honor, you just hit it on the head. The rule itself calls for variance, right? And I believe that's in .0900. And that rule says if it is not feasible for strict compliance, then the permittee can ask for variance. So in other words, the rule default is strict compliance, and that strict compliance is a prohibition against discharge.
So the problem here is that the MPCA kind of skipped over the variance process.
That's one of the problems.
I mean, there's, right,
Sure.
but on this particular issue.
On this particular issue, that's right. And the prohibition against discharge is clear from the rule. And yes, it is a stop sign. It does say that you cannot do this unless you have a control measure. And the control measure is a liner. And there have been liners in this project. There are liners other places. They have just simply chosen not to have a liner here. What they've done essentially is said the groundwater under the stockpile, under the basin, that just doesn't count. But that's 2,000 acres. For context, we're sitting on an acre right now. The state capital's on 1 acre. It's 2,000 times this of groundwater that they just simply say doesn't count. And they're saying that it can be contained, or we hope it can be contained by our system, and that's what makes this okay. But correct. And further, there's an unchallenged remand right now on a Maui analysis to figure out whether that leakage is a functional equivalent of surface water pollution. And so there is no complete prevention of groundwater pollution. There's a concession instead that there will be groundwater pollution of these 2,000 acres. And quite simply, the rule doesn't allow that on its plain language. And the Court of Appeals, in its decision, said that essentially it's an ambiguous statute or rule. And so we're going to defer to the reasonable interpretation. But if this is ambiguous, which we would submit it is not, then we look to the rule itself, its application before, and the rulemaking record. And I would point you to the 1973 comment that the PCA itself made, and this is in our addendum, when it made this rule. And it said that this rule, when it's talking about new pollution, seeks prevention of that. When we're talking about, in 1973, existing pollution, it was mitigation. But for new pollution, which this project will cause, prevention is the answer. A control measure must prevent that discharge from getting to groundwater, and simply this does not allow for that. And for that reason, this permit needs to be reversed to fix that error, but also it needs to be reversed to the public notice period so that we can get a better permit for Minnesota, a better process for Minnesota, and we can come forward to this court with a clean record.
Thank you, counsel. We'll turn to the respondents now. Mr. Smith, you have 13 minutes.
Thank you. Good morning, and may it please the court and counsel. My name is Bryson Smith, and I'm appearing on behalf of Respondent Minnesota Pollution Control Agency. MPCA's issuance of the NorthMet NPDES permit followed 13 years of review. Appellant's procedural challenge to this permit hinges on the claim that PCA sought to conceal EPA's concerns from the public. After a 7-day trial, the district court squarely rejected this claim, finding no evidence of any effort to suppress EPA comments and no evidence of any effort to omit documents from the administrative record. As the district court actually found, PCA worked hand in glove with EPA and facilitated an unprecedented level of public input. Regarding PCA's request that EPA delay submitting written comments, PCA agreed to give EPA additional time to comment on 2 subsequent revised drafts of the permit. Had EPA submitted written comments at any time or in response to any draft, those comments, as well as PCA's responses, would have been included in the record. In the end, EPA, exercising its discretion, chose not to comment or object, thereby allowing the permit to issue. Rather than reflect anything nefarious, this indicates that the final permit satisfied any concerns that EPA or some of its staffers may have had with respect to the early draft. Notably, appellants don't dispute any of the district court's factual findings, let alone argue that they're subject to reversal under the clear error standard. That alone is fatal to their argument. Regarding the core legal issue, appellants are not entitled to relief under MnStat 1469 unless they can show 2 things. 1, that the ultimate permitting decision was made on unlawful procedure or was arbitrary and capricious, and 2, that appellants' substantial rights may have been prejudiced as a result. Appellants conflate these 2 prongs, arguing that they were prejudiced by PCA's request that EPA delay written comments, but that request was not unlawful, and it did not render the ultimate permitting decision arbitrary and capricious. In any event, appellants were not in fact prejudiced, as both the district court and the Court of Appeals properly held. As with their procedural challenge, there is no merit to appellants' various substantive challenges to this permit. The reasons are numerous and are thoroughly discussed in our brief, but most fundamentally, this project will improve both groundwater and downstream surface water quality by capturing and treating ongoing seepage from an existing taconite processing facility, all while allowing for the extraction of minerals that are critical to our transition toward green energy. For all of these reasons, this court should defer to PCA's technical expertise by affirming the Court of Appeals decision and upholding the permit. And with that, I'm happy to answer any questions the court may have.
Counsel, you heard me ask opposing counsel about the enforceability of those internal standards. Could you address that issue? Are they enforceable? If so, by whom and in what fashion?
Yes, Your Honor. The operating limits are clearly enforceable. Under state law, no one disputes that PCA has the authority to enforce those conditions, and if they're not complied with, can revoke the permit or take other action to require compliance. Moreover, as a matter of law, those operating limits are not required in the first place because PCA is tasked with determining whether there's reasonable potential for discharges to exceed water quality standards.
But is it discretionary?
It is, Your Honor. So if there is reasonable potential, then it's not discretionary. So if there is reasonable potential, PCA must impose the Q-bells. If PCA determines there's not reasonable potential, it still has the discretion to impose Q-bells or operating limits, but it's not required. And
so, on that point, I mean, the internal operating procedures were one of the reasons that it was not that it was reasonably likely that they wouldn't exceed standards, right? I mean, that was part of the analysis, if I understand it correctly.
Your Honor, I would say the primary reason the agency found there was no reasonable potential is because the wastewater treatment process itself, all of the procedures of which are required by the permit and are enforceable, that treatment process is expected to treat all parameters of concern to water quality standards. So for that reason alone,
okay.
And then the operating limits are just a bonus. It's belts and suspenders, and benchmark to
and
ensure.
Just so I understand the operating limits, because it's not clear to me whether that was like all of this stuff that they do internally, you know, the stuff you were just talking about, or whether it's like a numeric standard that they're testing internally.
Right, Your Honor.
Is it that latter?
It's the latter. It's a numeric standard just to ensure that it provides a benchmark.
So here's I guess one of my questions is, if everybody's so confident that those internal operating procedures internally are going to meet, you know, like the 1.3 for mercury, why not just put a WQBEL in place that says the same thing at the point source? I mean, if everybody thinks that this is going to save everything, what's the downside of putting that in? That's the part that really kind of raises the red flags for me, quite frankly.
I think the answer is that PCA takes the textual language of the regulation seriously, and when it talks about, you know, needing to conduct this reasonable potential analysis, That's where the agency looks and says, okay, we're going to conduct this analysis, and it did that as summarized in pages 31 to 39 of the fact sheet. And after doing all this pilot testing, design modeling, and imposing the operating limit, said, yeah, there's no reasonable potential here, so we don't need
And
the
just to
QPLs.
clarify, what about cadmium and zinc? Are they in the internal operating, the IOPs?
I don't know every parameter of concern, whether it's an operating limit or T-bell, but those are accounted for in some form or fashion. And
Well, the T-bell is higher than the water quality standard, so it has to be
Right.
something other than that.
Right, so what the agency did is, if there was no reasonable potential for certain parameters to exceed water quality standards at the point where it even enters the train of treatment, it said we don't need to impose operating limits on that because, it doesn't even need to be treated. It's already below standards. So if there was a potential where it comes into the treatment train that you have to treat it to get it below, that's where you would apply these extra operating limits.
Okay, thank you.
The bands, I'd like to talk about the band's arguments here for just a moment. The band in its brief says they have a numeric quality requirement that the MPCA didn't address, and that the groundwater pollution here will exceed that numeric level. The point source pollution into the receiving waters will exceed this numeric number. How do you respond to that?
So as a threshold matter, I would note that the band takes an inconsistent position in its briefing. So in its opening brief, it says that those discharges have to comply with the band's numeric standards when the discharges reach the band's reservation boundary. Then in their reply brief, they pivot and say the discharges must comply at the point of discharge, which is over 100 river miles upstream. But in any event, the bottom line is that when you're ensuring compliance with the downstream state's water quality standards, what you do is make sure there's no measurable increase in concentrations or loading. And as evidenced by the final environmental impact statement, as well as the anti-degradation analysis, that's the case here. We have a net reduction in mercury loading downstream and no measurable increase in mercury concentrations downstream. What the band is asking this court to do is fundamentally rewrite the Clean Water Act in two fundamental ways. First, as the U.S. Supreme Court said in Arkansas v. Oklahoma, and as this court said in Annandale, the Clean Water Act is not to be given a rigid interpretation that precludes the construction of new facilities that improve downstream water quality. And so that's what happens here. As the record shows, there will be a beneficial impact on downstream water, and the Clean Water Act should not be interpreted to avoid that beneficial effect. And then secondly, as the Supreme Court said in Arkansas v. Oklahoma, downstream states take on a subordinate role to upstream states under the Clean Water Act. And the ban would have this court invert that by applying the downstream ban's numeric water quality standards at the point of discharge. Taken to its logical extreme, that would mean that when you have a discharge to a tributary of the Mississippi River in Minnesota, you would need to look to the numeric water quality standards of Louisiana and Mississippi. And I would submit that's simply an absurd result that has no foundation in the text of the Clean Water Act.
What do you say to the band's statement that Arkansas versus Oklahoma isn't pertinent because the anti-degradation analysis it was relevant in Arkansas only because that was the state standard, Oklahoma state standard?
So if you look to pages 17 and 18 of the EPA brief in that case, it says that there were additional standards at play as well. There were numeric standards in addition to the anti-degradation. And the way you address and holistically ensure that there's going to be compliance with the downstream state standards is by making sure there's no measurable increase in the concentrations of the parameters downstream. And that's what the record shows is the case here. And for that reason, I would submit that the precedent from Arkansas v. Oklahoma is directly on point.
Does the EPA have a different understanding of that as reflected in the records that we're fighting about whether we can consider?
I don't think so, Your Honor, because first of all, I would know it's important to focus on what EPA's official position is here. Here, there were some draft comments created by EPA staffers, but they were never submitted.
No, but in those assuming those draft comments come in, just making that assumption, is the EPA's understanding of that statute different than what you're articulating here?
So I think they flagged a potential concern for further discussion in March of 2018. And then subsequent to that, the two agencies did work collaboratively by meeting on several additional occasions. And, through the two further revised permits, they had more discussions. And in the end, as evidenced by EPA's official position not to comment and object, this permit satisfied any concerns that EPA may have initially had.
But Council, we don't really know that because of what I consider to be the irregular practice in that you had two agencies speaking to each other, but just those two agencies, and there were no written comments, which looks like it's been the normal course. So why shouldn't that weigh in our consideration here?
So, Your Honor, first of all, I'd point to findings of fact 38 to 42 of the district court's order, and that shows that there's no norm regarding EPA comments. Sometimes it comments, sometimes it doesn't, and then even when it does, sometimes it's before the comment period, sometimes during, sometimes after.
But it would seem common sense that it would be unusual for them not to comment in an issue as big as this, especially with all of the public interest, which it looks like that might have been a reason why there weren't, or at least a request to not have written comments.
So I think this project in and of itself is inherently unusual. It's sui generis. It's the first copper nickel mine to go through the permitting process in Minnesota. Moreover, PCA and EPA had far more interaction with each other regarding this permit than a typical permit. So I think the posture between the two agencies was very different for this project than a typical permit, where the only indication PCA might have of EPA's concerns is through written comments, and that's just not the case here.
What about the 2022 EPA comments on the later comments on the different project? Didn't that also address the banned water quality standards and how the Clean Water Act should apply there? You said that there's no official position of the EPA.
There was a reference to it. That's, again, a totally separate permit.
I understand that.
And it can be addressed in the context of that permit to the extent EPA has any concerns pertaining to any issues that might arise in the context of that permit. But with this permit, EPA...
But I'm just saying that reflects a different understanding than you're telling us today is PCA's position, right? Not
necessarily, Your Honor. Again, they're flagging a potential concern. They're not saying this permit fails to ensure downstream water quality. They're just saying, that 0.77 nanograms per liter standard is out there, and it's different than Minnesota's, and you need to be aware of it. And again, I think PCA was very much aware of it, and that's why they did the FEIS and the anti-degradation analysis, indicating that there will be no adverse impact on downstream waters. And if I just conclude, I would say that Minnesota statute 1469 is designed...
One other question I had, who requested that the comments be read over the telephone?
That was...
Did the EPA or did PCA?
EPA. So
EPA wanted to read their comments to you, orally at least?
Mr. Perard, who was an individual EPA staffer, chose to do that, yes. And PCA didn't know that was coming, so they were somewhat caught off guard when he appeared to be on the phone reading word for word from a document. But yeah, he took it as on his own initiative to do that, yes. If I could just briefly address the remand questions that were posed to council.
Could you remind me, he had been, was it the head of the water quality for Section 5 for 9 years? What was his exact position there? He's not just some staffer. He was an important guy there.
He was the EPA Region 5 MPDES permitting chief for the EPA Region 5, which encompasses several states, including Minnesota.
Address the remand question.
Sure, Your Honor. On the remand issue, first of all, we would suggest that there is no need for remand at all here. But assuming you are going to remand, I would just point out that EPA had every chance to comment, so there's no indication here that they would comment if you were to remand. Moreover, I would respectfully point out that I'm not sure this court has jurisdiction to order EPA, a federal agency, to remand. And as to the extra record documents that the appellants seek to get in, saying that EPA would somehow comment if this were remanded, what EPA actually said in that document, which again we don't think should come in, is that if it decides to comment, it will do so in writing. It doesn't say it's going to comment, so I don't think there's any need for remand.
But in terms of scope, is it reopening the whole thing, or could we remand just to give them the chance, EPA the chance to comment and you respond?
If you're going to remand, which again we don't think should happen, but if you do, then yes, we would say it should be narrow, and it should not be, no reason to open it up for the entire public. It should be focused narrowly on EPA.
Thank you, counsel.
Thank you.
Mr. Johnson, you have 12 minutes.
Madam Chief Justice, may it please the court, Jay Johnson on behalf of PolyMet Mining. I'd like to start just by stepping back to where the appellants started their entire argument and a little bit to what Justice Hudson was referring to. The arguments they're making here are the same arguments they made in the district court for 7 days of trial. They tried to say, and they said again this morning, that EPA comments would have come in but for MPCA asking. That is not what the district court found. The district court found that MPCA had no control over EPA's decision to issue written comments, and at most it could make a request. The court found no evidence, that's paragraph 140 of the findings of fact. The court found no evidence that MPCA attempted to suppress EPA comments, paragraph 142. The request to delay written comments, which is all it was according to the district court's factual findings, was not an effort to avoid written comments altogether or skirt a regular procedure or requirement, paragraph 142. And I would say in response to what Mr. Murdoch said, these factual findings didn't hinge on any legal determination about whether the procedures were irregular. These were factual findings about what happened during the 11-day period between when Mr. Pirard at EPA said, oh, I think EPA would like to send written comments in, and the end of that comment period when EPA entered an agreement with MPCA.
But counsel, as I read the definition or what the district court relied on or appeared to rely on as far as how they viewed irregularity, that I don't know that I agree with your comments as it relates to that. So if I'm wrong, help me.
No, of course. There are conclusions of law at the end of the district court's findings, which, of course, this court can review de novo. We would point to this court's decisions in Mampel and Peer and Leahy and say the district court was absolutely right that the only irregularities in procedure have to be violations of written rules or statutes. But that's toward the end when it says, okay, I've found all of the facts the district court has found, and I conclude based on those facts that there was no irregularity. It doesn't affect the factual finding that MPCA did not attempt to suppress EPA comments. That's just a finding of fact, and that's reviewed for clear error. And in fact, the other side hasn't even challenged the factual findings of the district court in this case. I mean, maybe implicitly, but they don't expressly come out and say we disagree and we think they were clearly erroneous, because there's no reason to think that. There was 7 days of trial, 130-something exhibits. It was well dealt with by the district court. They just didn't like the outcome. While I have a chance, and I'm very much open to questions.
Would you have preferred that the PCA had just not called them up and tried to not have those comments come in, let the PCA come in, and then you could have actually effectively responded?
I do think that PolyMet is somewhat caught in the middle here. I mean, as Mr. Smith pointed out, there's been 13 years of work, more than that by now, on these permits. We had no input on what MPCA and EPA did, and I think that's appropriate because, you know, that's a relationship between two agencies that are deciding among themselves the best way to handle it. And the district court made a factual finding there too, and it said, you know, EPA's goal in meeting with permitting agencies was to avoid later EPA objections. That's finding 56, paragraph 56. And that, you know, when EPA and PCA negotiated an agreement to delay the written comments of EPA, it was because MPCA hoped to resolve as many public and EPA issues as possible before EPA issued any comments. That's paragraph 138. And that was,
you know, you're citing the district court's findings, and the district court said the primary motivation was its belief that there'd be less negative press about the NorthMet project. And that just seems totally contrary to MAPA.
Well, I don't think the district court made any findings about whether that was contrary to MAPA, and I guess my view is
We get to apply the district court's factual findings to the procedures in MAPA, and one of them's arbitrary and capricious. And we have cases that say there are danger signals when agencies don't act as we expect them to. And here the MPCA asked not for written comments in a certain critical period of time, and the EPA eventually didn't issue any comments in like the biggest mining situation ever to occur in Minnesota, when in all of the other mining cases, there are written comments and there are responses. I mean, isn't that a danger signal here?
Well, even if you grant that it's a danger signal, I think that the actual arbitrary and capricious finding is to hold that there is no rational connection between the facts that MPCA found and the decision that it made. So even accepting that it might be a danger signal to ask, the district court's findings are still that EPA chose not to comment, and that EPA had 45 additional days to look at a more revised version of the permit, and then 15 days on top of that to look at the permit again, and it chose not to object. So even if PCA's motivations weren't pure, the end result, as found by the district court through this 1468 process, which I think is meant to resolve sort of ambiguities like this, the end result is that EPA chose not to comment, and that the concerns that EPA was raising in an unsent letter were addressed on the merits, and that the way PCA addressed Q-Bells and whatever other issues substantively wasn't arbitrary and capricious.
Council, I'd like to direct your attention to the internal operating procedures issue and whether or not that's enforceable, and also sort of a related question. This case really seems to be about the application of Q-Bells, and is that something that the record would reflect that your client objected to, that they didn't want? Is that what is underlying some of this discussion?
I don't think there's anything in the record that says PolyMet did not want Q-Bells, and, you know, effectively, PolyMet has to comply with a permit that's 480-something pages long. So it's not just operating limits, it's every detail of how this water treatment system operates is governed by the permit. And if PolyMet deviates from any of those things, including the operating limits, it's in violation of the permit. It's not going to deviate from any of those things because of its obligations under the law to comply with its permit. So,
Well, go finish your answer, yeah.
no, I was just going to say, so to the extent that, you know, would Q-Bells make a difference on how PolyMet behaves? I don't think so, because the rules are the same about the permit.
And just to clarify what the Q-Bells are exactly, so you have your internal testing. Would the Q-Bells basically say, coming out of the pipe at the point source, that it has to meet the water quality standards at that point?
It would have to meet the Q-Bell standards, which aren't necessarily the water quality
This is what I'm
standards.
asking about. Okay, I need clarification on this. Okay, thanks.
Q-Bells can be, I don't know in this case whether they would be, but they can be above water quality standards, because Q-Bells allow for dilution and things like that before the discharges reach the waters that they're being discharged into. But they are end of the pipe. You're right about that.
But it could be higher than the water quality standard itself.
It could, in theory, if there were. But the operating limits are at water quality standards.
No, I understand that.
Yes.
What about cadmium? What about these two, cadmium and zinc?
So I think Mr. Smith was saying this, and it's on page A17 of PolyMet's addendum.
Okay.
The reason that cadmium and zinc aren't in the operating limits is that the influent that's being treated is already below standards. Okay. So there's no threat from those constituents.
And I don't know if I missed this, but so do you acknowledge that the operating limits in the permit can be enforced by the EPA?
I guess I'm agnostic on that. I mean, to PolyMet, PCA is the enforcement agency. EPA can come in, I think, and take over permits in certain circumstances, but the permits are enforceable, and it's not like PolyMet has some kind of special deal with PCA that PCA is not going to enforce the permit. PCA is our regulator, and when PCA says do this, PolyMet does it. I want to briefly mention, because Justice Thiessen, you referenced the later EPA comments that aren't in the record. in a separate proceeding. And I would note that EPA in its own 401 rule, draft rule, that's at 87 Federal Register 35369, specifically says that the comments it makes in the context of the 401A2 hearing, that the agency hearing that, which in this case was the Corps of Engineers, does not accord special status to the EPA comments. So EPA is commenting, other people are commenting. Those comments, even if they were to be part of this record, which they absolutely should not be, don't make a difference to this case.
And that's in reference to the 2022 EPA comments on the separate matter?
I don't even know if, I think they were linked to maybe in a brief, and they're from a hearing that we had in May of this year that EPA was allowed to comment, and I would say as well that that was specifically about downstream impacts under Clean Water Act Section 401A2. So to the extent that there's concern about that, it's being addressed in that context as well.
And does that, sorry, one more follow-up, does that OIG, does that pertain to the OIG report, or you're just talking about the?
The OIG report is a separate thing.
Okay. I just wanted to, that's what I understood, but I wanted to make sure I was correct.
That's right. Justice Hudson.
Counsel, I almost heard you, or I thought I heard you suggest that the EPA is just sort of another commenter amongst many commenters. Was that the flavor you were giving that your comment?
No, I'm sorry if I gave that impression.
Okay.
EPA, and again, I would go back to the district court's findings. EPA has a special relationship here. MPCA asked EPA to be involved early in this process to streamline it, paragraph 55. Its goal was to avoid EPA objections. There were frequent phone conferences twice a month for 2 years with EPA and PCA that lasted an hour and a half each. So EPA had, it's beyond a commenter, and I think Mr. Smith was suggesting this, to the extent that EPA doesn't have to comment. It's not EPA's obligation to tell the public what it's thinking. EPA is working with PCA.
What's your best argument for why we shouldn't take judicial notice of the OIG report and the other document?
My best argument is the evidentiary rules, which say, when there is a document that has disputed factual claims in it, it's not the proper subject of judicial notice. You could obviously take judicial notice that EPA issued an OIG report, but they don't care about that. The appellants care about the specific claims in the report. And if you look at the report, Region 5 itself was disputing some of these claims, like it didn't follow its standard operating procedures. Region 5 disagrees. That's a fact dispute. So it would be improper, in my view, to take
Where do we find that,
judicial
evidence
notice.
of that they disagree?
If you look at the report, there's a section at the end that's about responses. So the OIG is a separate sort of independent EPA internal agency. It made these comments, and there's a section at the end for Region 5 responses. I think some of them are in the WaterLegacy addendum. And sometimes it'll say not concur with comments. EPA Region 5 saw this comment, it didn't agree. That's a factual dispute.
Thank you, counsel. Your red light's on.
Thank you.
Now we're going to go to the rebuttal. Ms. McAbee, you have 3 minutes.
Sorry. My apologies for the delay due to shortness. I think the most important thing I want to emphasize is that remand is not the appropriate remedy because it doesn't address the question of EPA's oversight jurisdiction, which is governed by 33 U.S.C. 1342, which is the NPDES program, 40 CFR Section 123, and the Memorandum of Agreement, which is Exhibit 328 in this record, and at least parts of it are in our addendum, though you might need to go to the record. And so it's necessary that this permit be reversed and reissued. And that is necessary so that there would be a reissuance, which is the condition under which the OIG recommended that EPA would submit written comments, and they said if the permit was reissued, their comments would be in writing. And also, I think there's been a lot of discussion We believe that Q-bells are needed as a matter of law, but what is absolutely clear on this record is that EPA was excluded, the public was excluded, and MPCA's decision was arbitrary and capricious under a number of standards of this court. There's a danger signal.
Counsel, what do you do with District Court finding number 142?
Pardon?
District Court finding number 142, where the court said, the court finds no evidence that the MPCA attempted to suppress all EPA comments.
We do not dispute the court's factual findings, but we do not believe that the MPCA needed to be interested in suppressing all comments in order to have acted in a way that was irregular, unlawful, arbitrary, and capricious.
So on the arbitrary and capricious standard, generally sort of at a 50,000-foot level, we look to see whether the agency gave this a hard look. That's a standard you see in our cases over and over and over again.
Good point.
This process took 13 years. How can you say they didn't give it a hard look?
Your Honor, we can say that the permit decision itself didn't have a hard look because it didn't consider its own EIS statement that Great Lakes procedures needed to be used and there had to be Q-bells. So they didn't even follow their own EIS. And then there was no consideration in the record of EPA's statements that the Great Lakes required mercury Q-bells and required a new procedure for the determination of reasonable potential. So if you look at the reserve case, danger signals, it's arbitrary and capricious. If you look at the Card against Candiyohi case, there was a very important factor, namely EPA's, a co-regulator's opinion about what's federally enforceable, what are federal laws, and the MPCA didn't deal with those. So on a number of standards, including the hard look that Your Honor suggested, this decision was arbitrary and capricious. It needs to be reversed for that reason, and so that agencies would not be rewarded if they go ahead and they circumvent.
Maccabee, do you agree, though, that nothing stopped the EPA from stepping in? It's not like the MPCA has, they're big boys and girls, and they could have stepped in at any point, either during the comment period or even after the comment period.
Your Honor, the MPCA's conduct is what's at issue here. That is what this court has the ability to rule on. And this record shows that the MPCA circumvented its obligations under 40 CFR 124.17 to provide written comments in the record when there was a comment made during the public comment period. They unlawfully destroyed public records, including violating the Officials Record Act, and they covered up their tracks.
Can I ask just one question on that? So say there's a public comment period, people can submit written comments. Can public members also just appear at the hearing and submit oral comments, and the MPCA has to respond to those oral comments as well? Or do they only have to respond to written comments?
Your Honor, there's some case law that says anything during the public comment period has to be responded to, but there is absolutely nothing in the law or in case law that says that comments after the public comment period have to have written responses. So
no, I'm asking, like, during the comment period, a member of the public comes in, doesn't write into the MPCA, but appears at a hearing and raises a concern. Does the PCA have to respond to that concern?
that is correct.
Thank you, counsel. Your red light's on.
Okay.
Mr. Murdoch, you have 3 minutes for rebuttal.
Thank you. Do I have a chance to sum up or am I done?
Your red light's on. Thanks, counsel. Mr. Murdoch.
Thank you. To briefly address Mr. Smith's argument about any inconsistency about the band's position, the numeric criterion requires compliance at the reservation boundary. Of course, MPCA never analyzed any of this. Why it requires compliance at the point source is because all the waters below, all the downstream waters exceed the band's mercury standard. So it has to discharge at 0.77 at the point source because it can't be diluted by the time it reaches the band's reservation boundary. And so it's not inconsistent. It's just how you would comply with the numeric criterion in this instance. And again, MPCA never even analyzed the issue. Federal law requires compliance with the downstream water quality standard. This is 40 CFR 122.4D. Again, this court recognized in Annandale the issue in Arkansas versus Oklahoma was Oklahoma's anti-degradation standard. What happened was EPA interpreted Oklahoma's anti-degradation standard to be violated if there was a measurable change to existing water
So
quality.
can I just go back up for a minute? So is the test for when it reaches the band's waters, so get downstream, that it has to meet that standard when it gets there?
Correct.
And so so assuming it came out at a higher level at the point source, if there would be time to dilute it, arguably it could still meet it, as long as, I don't know what the mechanism would be, but as long as at the time it gets to Fond du Lac, it meets the standard, that would satisfy this issue. But what you're saying is, A, that can't happen here because it can't be diluted, and second, the MPCA didn't look at it at all.
Correct. It needs to comply at the reservation boundary. That's EPA's sort of longstanding interpretation of interstate sort of pollution, water pollution control. And yes, the issue is that you can't dilute mercury you can't dilute PolyMet's discharges with water that has higher mercury concentrations. It's just.
Oh, because it's already high.
Right.
Okay, I got it.
It needs
Sorry.
to be 0.77 by the time it reaches the reservation boundary. But all the waters that lead all the way there are like 4.6 nanograms per liter.
So
you
does
can't
this mean
lower
that that no mercury can ever be discharged upstream of the band?
It needs to meet the band standard.
Oh, it could come out of the point source at the band standard.
Right,
and then it would
which
be
is
okay.
which
I
is
got it.
why
Okay,
Mr.
sorry.
Smith says it's inconsistent. It's not
I
inconsistent.
got it.
It's just explaining how it can be complied with. It doesn't block discharges. PolyMet contends that it could actually meet this standard. It's basic compliance, and that's why Mr. Smith's hypothetical about Mississippi or something, it dilutes when it's thousands of miles downstream, but here it's just not possible. Again, MPCA never analyzed this issue. And I would also highlight that the mercury analysis is completely unsupported. MPCA never tested the types of water that contains high concentrations of mercury, so there's just no basis for it. And if I could just finally highlight a Second Circuit decision we cite called Atlantic States, that is sort of the issue here about the operating limits. And I'm out of time.
Thank you, Counsel. And Mr. Nelson, you have the last word for 4 minutes.
Went the wrong way both times. Thank you, Your Honors. It's been a long morning, and so I'll briefly summarize. First, I didn't hear any argument about the groundwater rule issue, and I don't want that to be lost. I think that this permit allows for a pollute, then hope to capture process. And the groundwater rules of this state simply do not allow for that to happen. It has to prevent pollution before it gets to the groundwater, and that's a liner. MPCA knows how to have a permit with a liner. PolyMet knows how to have a liner in place because the permit calls for liners underneath the other stockpiles.
Do you agree that there's a variance process in the law here?
I would agree there's a variance process, but it has not been availed.
Okay.
And it has separate findings, and those findings have not been made. And so if this is to be reversed and remanded, that's another issue that can be dealt with in the first instance, and then we can be scrutinized later on. Which then brings me to the second point and the most important point, I think, of the day. And that is the finding that is unchallenged and has been cited many times today is that the primary motivation was to avoid negative press. That is a motivation to avoid scrutiny. That goes to the very heart of MAPA. It goes to the very heart of this court's role in the permitting process, which is to scrutinize the agency's permitting decisions. This decision was arbitrary and capricious because it intentionally skipped steps of the decision-making process.
Counsel, that motive argument you're making, that's District Court finding 121, that's what you're relying on?
I apologize, I don't know the number, but I believe that sounds right, yes.
But is that in conflict with, and maybe you're saying it doesn't matter, is that in conflict with that they didn't try to suppress finding? So it doesn't matter if they tried to suppress as long as their motivation, that's the irregularity, that their motivation was to keep this out of the press and not have them comment,
Sure.
basically?
First,
I mean, I don't see exactly how those are consistent, but okay.
I'm going to split hairs for a second, but I'm a lawyer, so I can do that. I think the finding was that there was no attempt to suppress all comments, right? And that's not challenged. But there is there's no doubt, there's no dispute that there was an intentional attempt to delay, which in other words, don't submit these comments during the public comment period that we know are coming because we don't want to deal with them. That's the unchallenged
Where does the District
finding.
Court find that because we don't want to deal with them? Where does
Because
the district court say that?
there are findings that the district court made under the findings and conclusions of law that had there had been a written comment by the EPA, the law would have required PCA to respond in writing to those comments. And that response to the comments by the agency, not by the lawyers and briefs later on, but by the agency, that's what's missing.
But the problem I have with your argument is that, as I understand the district court's findings, EPA and the PCA made an agreement that they wouldn't submit comments during a specific period of time, but then the state agency was going to send the draft to the EPA and give them more time to provide comments. That was the agreement. And then the EPA chose, at the back end, not to submit comments,
And I mean, you're
according
right.
to the findings.
And that is what happened. But again, we're here not to talk about what EPA did or didn't do. We're here to judge the conduct of PCA, right? We have no jurisdiction over EPA. We've said that before. There's no dispute that PCA took intentional actions to avoid these comments that it knew it would have had to respond to. And that gets back to what the statute says. The statute says that if our substantial rights may have been prejudiced, then the relief is appropriate. Our substantial rights may have been prejudiced. There is a potential for prejudice because of this intentional act of the PCA.
Can I just ask one, I still don't understand. So the extension of time, would that have been public comments? Or would those have just been so there's a public comment period and there was a question of whether that would happen during the public comment period. And then there's this extended time just for EPA, as I understand it. Are those public comments or are they just more time to comment?
And may I respond, Your Honor? Thank you. The extension of time and the fact that there were more conversations with EPA were just extensions for continued conversations between EPA and PCA.
So those would never have become public comments?
We have no idea what they would have said.
Chief,
Unless there would have been a written comment, of course. There was no such written comment. That's a different consideration because we're talking about what PCA did in the moment that it took the extraordinary, irregular, and lawful steps it took.
Hang on, Justice Hudson.
Yeah, I'm trying to get clear as well. I thought I read something in either PolyMet's brief or somewhere that even because of the comment period, which ran from whatever it did to March 18th or something of 2018, that even if EPA had responded with written comments, say on March 18th, the appellants would not have had time to respond in any event. So it goes to the prejudice piece. I mean, can you address that you wouldn't have had access to that information? And again, maybe I'm remembering the record wrong, but.
Yeah, there's a question of timing as to what we could have done had the comments been published at the time they would have been published. And perhaps it would have been a rush job, perhaps it would have been a lot of lawyers working very quickly to get something out, but the real point here is we don't know. We don't know what would have happened, and that's the problem.
Thank you, counsel.
Could I ask just
Yes.
one more question? Sorry about that. But am I right that the destruction of evidence was any sign in the MPCA's documents that there was even this agreement between the EPA and the MPCA?
The evidence that was destroyed was evidence that PCA made the ask, that it was PCA's action that if PCA affirmatively reached out and made this ask to please don't send in comments, that was what was destroyed.
Okay, the ask, but the agreement came in through something else?
There was evidence that there was an agreement about an extension of period of time for PCA and
But it
EPA to
didn't show
consider.
the ask.
It did not show the ask.
Thank you.
No,
Yes.
I don't have another question here.
Okay.
But I asked a question about whether oral comments have to be responded to. Could the PCA come up and just answer that quick? Because
Okay.
it's a little irregular, I know, but
Nothing about this case has been regular.
Thank you, Your Honors.
Thank you, counsel.
Thank you, Chief. And so the question was, if someone comes and just makes an oral comment at a public hearing, then you would have to respond. I am assuming part of your answer here is these were not comments made at a public hearing, so they don't have to be responded to for that reason. But generally, in procedure, if a comment is made orally but not in writing, do you have to respond to those?
So when there's a public hearing and you have members of the public there making oral comments, there's typically a stenographer there who will type them out, and yes, the PCA would respond to those in
Okay,
writing.
thank you, that's all I had.
Thank you, counsel. Thanks to all counsel and to the amicus counsel as well for the help you provided to the court in this matter. This case is submitted. We'll issue an opinion in due course. We're in recess.